The first I have is Cerise Loomis, Loomis. She's an inmate. And I have Loomis, who's an inmate. And for the record, Judge, that case number is 23 CF 369C. I believe it's a Crestview case that was transferred down because there's a new law in this division as well.
Hold on 1 second. I'm still trying to get past the audio on this. I'll make sure they can hear me. I've got my audio muted. Let's see if there's a way to turn that on. And not muted, but it's going to echo.
This was information was filed late, so I just want to make sure you got that.
Mr. Neal, can you hear me?
Yes, I can, Your Honor.
I just want to make sure I'm playing around with the sound. Okay, Ms. Jacob, and now we'll start de novo.
Thank you, Your Honor. Cerise Loomis, 23 CF 369C.
Okay, yes, ma'am.
Are you Ms. Loomis? Okay. Your Honor, I was just appointed to this case, so procedurally I'm not sure what has happened yet, but for today's purposes, I'm going to enter a denial. There is a new law, 23 CF 1594. A not guilty plea has already been entered in that case, and I would just ask that this case run along with that one. I believe that's set for the September 11th pretrial.
Okay. So, Ms. Loomis, I'll see you back here on September 11th with all of your cases. Okay?
Oh, so it'll be transferred over here to this court instead of the Crestview, okay.
The BOP will run along with the new law.
Yes, ma'am.
Okay, thank you.
And Your Honor, just as I think I told the court before, but I was just appointed to Ms. Loomis's cases, so unfortunately I've not had an opportunity to meet with her, and she popped up on today's docket, so I wanted to go ahead and call it, but I'll meet with her as soon as possible.
Sounds good.
Can I give verbal permission for Andy Miles?
I'm not going to speak with anyone until I've spoken with you at the jail, okay?
Okay.
Thank you, thank you.
Judge, Your Honor, I'm double booked actually. I have one case in Judge Ketchel. May I be excused to go handle that real quick and I'll come right back? Thank you.
Yes, sir. Thank you. Ms. Jacob, your next case?
Daryl Shaw. And that'll be followed by Tyler Lunsford. And just for the court's information, Mr. Lunsford is actually on the 130 docket, but I'm not really sure how my name got put on the case. And he wants to plead pro se. So I just wanted to address that this morning, if the court will allow.
Yes, ma'am. Is Mr. Christian Moore, is he here?
He's not here yet.
Thank you.
Your Honor, this is Daryl Shaw before the court in 15 CF 1264. Your Honor, I'd like to set this for a contested hearing, but I'm going to ask that the court set it for whatever the 1st October date is. And the reason I'm asking that is because I still have not received the discovery in this matter. So I still don't have a formal score sheet, although the state has informed me of what it would reflect. But also there's a new law violation that no attorney was ever appointed for. So I'd like to get the discovery for that as well so that I can prepare for the hearing.
Okay, so October 9th, and you want it in the afternoon or the morning?
Yes, the 2:30 with subpoenas.
Okay, it'll be 1:30 because we don't have arraignments that day.
Okay, 1:30 then, yes.
Yes, ma'am. So Mr. Shaw, I'll see you no later than October 9th.
Till then, Your Honor.
Thank you, sir.
Thank you.
And Your Honor, I saw Mr. Lunsford in the feed, and as I previously announced, Mr. Lunsford is on the 1:30 docket. That case number is 23 CF 1438. And Your Honor, as to Mr. Lunsford's case, the PD was never appointed. Somehow I got put on that case. Mr. Lunsford, however, is wishing to plead pro se in that matter. I was provided a You can hear it.
Your audio is playing.
Of the plea agreement, which I had then provided to Mr. Lunsford because I was representing him in some misdemeanor matters. But from the very initial beginning, Mr. Lunsford had indicated that he planned to admit and accept the offer. So there's no reason for me to be on this case. He can save himself a little bit of money that way.
Okay. What's the offer?
It is a withhold of adjudication, 2 years of probation, $615 in court cost,
Okay, I was just making sure it wasn't prison or something.
No, sir, it's a withhold in probation, which is one of the reasons that Mr. Lunsford, he told me what his prior history was, and I said, well, if that's the case, if you plan to plea, you don't need me to be there.
So your motion to withdraw is granted?
And I know that Mr. Gomez just stepped out, Your Honor. I can show this to one of the other state attorneys real quick, if you want to just address Mr. Lunsford's case now.
That'd be great. Good morning, Mr. Lunsford.
Good morning.
And Your Honor, if you'd like, I can actually just approach.
Please, thank you.
And I know that Mr. Lunsford had expressed a desire to ask the court to waive the cost of supervision because he has been in jail for the last 2 months, likely lost his job that he had. And so those notes on there in purple, Your Honor, are mine. So those are not agreements with the state, just my notes.
Okay. So to the state, is it my understanding, Mr. Gomez, this is Mr. Lunsford?
Okay.
From Woodard.
It's my understanding that the state has offered Mr. Lunsford a plea withhold of adjudication, 2 years probation. You'd have to pay the $40 per month cost of supervision, the court cost. I'm not aware of any other terms.
They're marked on there, Your Honor. I apologize. Just as a friend of the court, it was a substance abuse evaluation and treatment, and I believe there were 12 hours of community service.
24 hours.
24 hours.
Community service. Okay. Good, thank you. Mr. Gomez, do you need to see this sheet?
No, Your Honor, I agree with those terms.
Okay. Mr. Lunsford, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You put your hand down. Mr. Lunsford, do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, sir.
You're also waiving your right to an attorney. Do you understand that?
Yes, sir.
Have you ever been on probation before?
I have.
So you know what you're getting into?
Yeah, I sure do.
Okay. Mr. Lunsford, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You'll need to pay the $40 per month cost of supervision. And let's talk about that, okay?
Okay.
You'll need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today.
Okay.
Perform 24 hours of community service work. You'll need to pay the court costs. How much money do you make per month, Mr. Lunsford?
Currently, given the circumstances, I've lost my employment. I might be able to get it when I get back out. Right now, I'm in the restaurant business, so I'm a tipped employee. It just kind of varies depending on the season, so probably not much right now.
What,
A rough estimate?
how much did you average making over the last 5 months?
In the last 5 months, maybe
Per month?
per month. Okay, yeah, 1,500.
Okay. I do waive the cost of supervision, Mr. Lunsford.
Thank you.
Sir. Thank you. Okay.
Judge, if I may correct that, it's what she is.
Oh,
Yes, sir, Mr. Lunsford.
Is it possible to pay off the community service hours when I do get employment?
To the state, any objection to that?
I have no objection, Your Honor.
Yes, sir, you can.
Okay, thank you.
Thank you, sir.
And with that, Your Honor, that's all I have. May I be excused?
Yes, ma'am, thank you.
Thank you.
Yes, ma'am.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I have one case on your docket this morning, and that should be Michael Porter. Case number 21 CF 1835. It's a VOP. Your Honor, I've spoken with Mr. Gomez, the state attorney, and the probation officer on this case. I think what we would like to do, the court will grant us another continuance. My client's working on wrapping some things up that were due on his probation to try and reach a resolution on this case.
To the state.
That's correct, Your Honor. I was in discussion with Mr. Cotton about this as recently as yesterday, and we're just wanting to give the defendant a little bit more time to complete the original terms of probation.
Okay, when do you want to reschedule?
How long do you need?
About 30, whatever you got, about a month, 4 to 6 weeks, if you've got something in there, Judge. Part of it is he's got to complete some, one of them is he's got to do an eval and complete some treatment, so at least I need to get him started. I don't know what his treatment requirements will be.
Okay, since we only have one miscellaneous date in September, and that's probably going to be slammed, we'll probably set it for October 9th.
Works for me, Judge.
So October 9th at 9 o'clock.
Judge, that's all I have on your docket.
Thank you.
It's good to see you, thanks.
Continue.
Yes, sir.
Okay, Elijah White. What's going on now?
I'm here on Mr. White's behalf, Judge. He's supposed to be at the jail on Zoom.
Yes, sir. Hello, Mr. White, can you hear me?
Yes, sir.
Good.
Yes, sir.
Okay, thank you. Okay, Mr. Nettle, I know that you were just appointed July of this year, just last month. I wanted to make sure that if you had the opportunity to speak with Mr. White.
Yes, Judge, I went to the jail and he and I spoke. I saw that there was his mother, I believe, or Jennifer White, had filed some correspondence concerning his mental health. So I went and spoke to him. To me, he doesn't appear to have any mental health issues. At least I'm not a mental health professional, but from my experience of speaking with him, he seemed to have a pretty good grasp of what's going on and what he's facing.
Yes, sir. What do you wish to do regarding Mr. White's cases?
Well, after I spoke to him, I decided I would go ahead and sign on to him, so I filed a notice of appearance. And then I believe like 2 or 3 days ago, I think it was like 15 downloads. He's got 9 separate cases.
Yes, sir.
But almost 10 hours of downloads to my computer, about different video files and et cetera. So I do have the discovery now from the state. Once I get a chance to go over it, I'll be contacting the state attorney to see what we can do.
Okay, so do you want all of them to be set for the next pretrial date, September 11th?
I believe that for September 11th, Judge.
Okay. So, Mr. White, I'll see you no later than September 11th. I think I made a note somewhere about your birthday coming up next month. And I think that's before your birthday, so I'll see you on September 11th, okay?
Yes, sir. Thank you.
Thank you, Mr. White. Thank you, Mr. Neville.
Thank you, Judge. That's all I have.
Yes, sir. Then next is Mr. Switek. I don't see Mr. Switek in the courtroom. Let's see what pro se's we have. Still has Mr. Moore here, Christian Moore. Nope. Okay. Mr. Scott. Mr. Scott, we're going to do your case. Hello, Mr. Wooden.
Hello.
Mr. Scott, can you hear me? Hello, Mr. Scott. him to start the video. Does the state have any cell number for Mr. Scott, or
We do, and I will contact him, Your Honor.
you want to, here we go, here he is. Mr. Scott, your video is, there you go, good. Thank you, Mr. Scott, can you hear me?
Good morning.
Good morning, sir. Mr. Scott, I'm here with Mr. Wood. Let's see, I did my homework. Hold on 1 second. So it's a petition for certification of material out-of-state witness from the state, correct?
Yes, Your Honor, and Mr. Wooden filed a motion to dismiss in habeas corpus.
Was that accepted by his attorney?
Mr. Wooden is pro se, Your Honor.
Okay,
Mr.
then-
Scott is standby counsel.
Gotcha, thank you. I didn't see Mr. Wooden's motion, I stopped when I did. Why don't we do the state's petition and then I'll pull up Mr. Wooden's motion. Mr. Wooden, have you had an opportunity to read the state's petition for certification? Have you seen that?
Make a cream call, sir. I pay no attention.
I'm sorry, can
I honestly don't understand exactly what you're talking about. Right? But if you referring to the motion she filed for the continuance to speak to the witness,
Correct. Yes, sir.
No answer. I got no answer.
No what?
I got no response to that.
Okay. To the state?
Your Honor, we're just seeking that Mr. Shepard be certified as a material witness so that we can subpoena him from out of state of
Yes.
Texas.
And that petition is granted.
Thank you, sir.
Okay, now, Mr. Wooden, let me see what else is set for today. And when I say set for today, the docket just says motion hearing, so I just did the one case, or the one petition, I didn't see the other motion. Do you have a docket number for those other motions, Ms. Fenton?
Your Honor, on 7/20, we heard a motion to dismiss and continue this today. And then
So motion to dismiss. When was the motion to dismiss? Okay, I've got it. Motion to dismiss in habeas corpus filed on May 23rd. Okay. And I may have- Yes, sir. One-page motion, I just read it. Mr. Wooden? Argument? Or if you want to present any evidence, this is the time to do it.
My opening and closing statement is typewriter.
Is typewritten?
Typewriter.
Is typewriter?
Yes, sir.
Okay.
In conclusion of that statement, I have some few comments. You allow me to refresh the court's memory.
Please.
In the basic due process, I'm allowing rights to certain aspects to my defense. But what I'm saying now is that in further proceedings from today, and the results of what happened today, I'm asking that I'll be able to speak to the board of commission, to speak to the superintendent, and in fact, the chief of justice, as a result of today's motion. I'm also to the first you remember, sir, the state did ask for continuance on the status hearing date. We did apply to the DA in court to only address in court through motion before the actual court date and actual hearing. We scheduled for trial in the previous court date, and we were supposed to, which should have resulted in proceedings and due process. And results of that, sir, without bias of the court and judicial process, results should be varied as far as dismissal or per se acquittal, because the state did ask for it, and that would be acting bias on the state's part. And also, to refresh your memory, sir, I previously applied for bonds and a pretrial release, and based on the results of the past hearings and the results of today's hearing, based on your decision to move forward, I believe that I want to use a better word for qualify for a pretrial release due to that the state asked for a continuance on the trial date and still would like a continuance, and we had set permanent trial dates, and now that we have a new permanent trial date and possible new evidence that I have not seen or other variables that may add to the equation of due process, I believe at this point it's safer for me to move forward in defense of myself, and better words, lack of words of saying freely, because without bias, I believe the court has rendered some clerical error and basically I've been lacked of procedural rights, and to fix those before they become fully permanent or certain variables to which should be included with the decision of today's motion, to allow me to safely defend myself, that I should be qualified or at least some type of relief to allow me to defend myself until trial. And one more comment upon it, based on the results of this today's hearing. I would like to also, if I'm able to speak to the superintendent, for him to understand what I'm requesting, basically, at this point, the board and the superintendent should be a part of all procedures from here on, because we're technically in trial phase, and I'm requesting direct contact. That's it, sir.
Okay. Mr. Whitman, so here's what I've gathered from what you've stated, is that you believe that because the court granted the state's motion for a continuance, that has violated your due process. Is that one of your arguments?
No, sir, I'm not making valid. I'm not make valid points off of decision. All I'm saying is, based on the previous events and the way they're planning out, that I don't want to say overqualified, but without strenuous court processing, that I should be qualified for some relief, which, to make it simple, I'm asking for a pretrial release simply here as a result of today's motion hearing, which may result in a motion to dismissal, or actual dismissal, or whatever else that may be included into the motion. The motion is based on the indictment phase and whatever other evidence that the state may have put into the rebuttal of the motion, or whatever the case may be. It's upon your decision, sir. And I'd just like for you to refresh your memory of the rules, procedures, and protocols that come with following the decision and a motion dismissal. See what I'm saying, sir?
A lot of what you say is not legally, I can't follow it legally. You use a lot of buzzwords, but they don't fit together. If you're seeking pretrial release today, if that's the ultimate goal that you're seeking, because you've used that more than once, is that the relief you're seeking today?
I'm just refreshing your memory upon the decision of the motion, sir.
Let me ask you this.
I gave him
What relief are you asking? What are you asking the court to do today? If you win today, what does the order say? What is?
If I went today based on the proper protocols upon the motion to dismiss, sir, it would be a certain list that I feel that I'm qualified for. Factors that may include dismissal or removal of some form of false entry evidence, some form. If not, then that's your decision. I'm actually outside, I'm just refreshing your memory outside of the hearing, because this may be the last time I speak before the DA puts up for it and you say your final decision. And based on these factors, that I'm also asking verbally here now to be granted a pretrial release, so I can defend myself.
Based on what factors?
Today's hearing, the motion hearing.
Okay. Mr. Woodard, again, you've talked a lot. You just haven't said a lot that the court can act on. Every fiber in me just screams out, I wish that you would let an attorney help you, because they...
Yes, sir. I understand that. I will not go around here with biased decisions. If you would go forward with the decision for the motion hearings, I'm sticking to rules and protocols, sir, and that's all I'm asking.
Okay. And certainly I'm
I
not...
would also refresh your memory again I would like to speak to the superintendent.
Explain to me who is the superintendent?
Sir,
or what is the superintendent? Because you mentioned board. Is the superintendent of some board?
The Board of Commissioners, sir.
Which commission?
The Florida Commission.
The commission of what? It's got to be a commission of some, is it the county commission?
Sir, your superior is the Chief of Justice, and his inferior or superior would be the superintendent. You should have direct contact with the superintendent all the time, sir. How can you establish him for trial without knowing the superintendent, sir? I don't understand. Are you the head judge in this court? May I get a roll call, sir? I need to know who is in this court.
Mr. Williams, certainly I'm not the head judge of the state of Florida.
But you commission court tell, sir.
Mr. Williams, hold on. What I'm wondering is, I'm going to go back and do some research about competence for you to represent yourself, because just about everything you've said today is, Mr. Woodard, just the majority of the things that you've said today aren't intelligible to the court to try to act on those.
Hey, somebody call a federal officer, because I'm clearly being kidnapped here. Some sort of, this process is.
Mr. Woodard, if you want to leave the courtroom, you can. I'm going to continue to stay if you leave. Okay, for the record, Mr. Woodard's left the courtroom to the state. I will look back because just so many of the words and what he's used. You know, my understanding of the case law is that it doesn't mean that that a defendant has to have gone to law school, that they can do all those things, but they have to be competent. And so I'll look back at that. Just so many of the things he was saying today, if not all of those, just aren't legally cognizable for the court to act on. That's why I was trying to figure it out. So I have concerns about Mr. Wood, and I'll do some research on that. And then maybe sua sponte, enter an order based on that.
The state shares the court's concerns, Your Honor.
When is he set for a pretrial on September 11th?
Yes, Your Honor.
Okay. Let me make a note. So Mr. Wooden's motion for habeas corpus and motion to dismiss is denied. I'll see Mr. Wooden back here no later than September 11th. It'll probably be in the afternoon since he's an inmate. But I will do some research and maybe enter an order based on that.
Thank you, Your Honor.
Thank you.
My business with the court is concluded. May I be excused?
Yes, ma'am. Thank you. Mr. Switek.
Good morning, Your Honor.
Good morning, sir.
John Switek on behalf of Jared Pierce.
Well, Mr. Pierce.
It's 2018 CF 2647.
Mr. Pierce, motion for a clarification on the court's order modifying probation.
Right.
Court ordered that the defendant was allowed to have supervised contact with his sister, see the order, and that you said that the department is still refusing to allow that.
That's correct, Your Honor.
Okay. Anything else you want me to know? Yes, ma'am.
Judge, if I may,
Please.
as you're well aware, you ruled, I believe, June 12th, that Mr. Pierce may have supervised contact with his minor sister only to include overnight stays. Probation has indicated to me that they needed an amended minute sheet that basically says unsupervised contact with his minor sister to include those overnight stays. Otherwise, they're not able to do that. However, when I reached out to the clerk's office, they said they couldn't change the minute sheet, so essentially, that's why we're here.
Okay, so what does the order need to say?
Unsupervised contact with defendant's minor sister only to include overnight stays. And once they have a minute sheet reflecting that, they have no issue.
I think the point being is that the court ordered supervised contact and probation needs it to be unsupervised.
Okay, does the state object to that?
Judge, we objected to him being allowed to have unsupervised contact or overnight stays in the June hearing, so we'd renew that objection, but I did also just want to explain as an officer of the court the confusion between probation and the clerk's office and the state attorney's office.
Which would beg the question, what's probation's beef with supervised contact?
I believe probation's position was if he's going to be overnight in the same place as his minor sister, there's inevitably going to be some unsupervised contact because there will be times when people are sleeping and there won't be any supervision.
So supervised and overnight are inconsistent, basically.
Yes.
Probation, anything you have to add?
That is all that I see in the case notes as well.
I'm not willing to put unsupervised in the order. So I don't know what to do.
Well, the intent was to allow the siblings to be in the same residence. I mean, we've got to craft something that allows for that. I don't know that people being asleep necessarily is unsupervised. They're in the same residence.
I don't disagree with you, but I'm not going to use the word unsupervised because that's too broad. Probation, any other terminology that may accomplish what the court's seeking?
It's either supervised or unsupervised, and I don't believe that his officer is recommending that.
Is not, the case officer isn't recommending, they're just saying.
What if we added a sentence that people, adults sleeping in the same residence is not considered unsupervised?
I certainly agree with that.
And I'll do a modified order and get it over to you today, Judge.
Okay, if you'll send it to the state first.
I will.
And if he could just clarify what the minute sheet should say as well.
Well, the minute sheet should say that the order is going to be amended and sleeping adults are not considered unsupervised supervision.
If you hold on one second, see if I can wordsmith something.
What is your sister doing?
How about, in quotes, supervised contact, close quote, includes overnights with the minor and another adult? Probation?
His officer just contacted him and saying any overnight would be unsupervised.
Understand that's what they're saying. Thank you. And if probation won't honor that, then I think we need to have an evidentiary hearing and have that officer here and find out what regulation states that that's not accurate and why this order can't be enforced.
Okay. Judge, would you mind repeating that? Supervised contact?
In quotes, supervised contact includes overnights with the minor and another adult. to say, and an adult other than the defendant. How about that? And an adult other than the defendant.
Perhaps we should include her initials as to who the minor is.
Okay. And the minor initials are
I believe it's JP,
JP.
and that would be JP only.
Well, when you say JP only, okay, yes, ma'am. It's only applying to JP, correct? Okay, good, thank you. Good, thank you, ma'am.
Not to open up another can of worms, but in Walton County recently, I had a case where probation violated my client, even though there was somebody over 18 in the house, saying that 18 wasn't an adult as far as probation was concerned. I don't know if we need to address that, but it's probably superfluous.
If you want to put in parentheses minor JP only and an adult, if you want to put 18 years or older, that's fine.
Your Honor, his officer just said if we could put in that his sister is allowed to live or reside at that residence, that should take care of everything.
It's not going to be able to live or reside there without supervision. Okay. So again, it's too broad. But thanks for trying. I know that helps y'all out, but I've got to make sure that the child's protected. Thank you.
Thank you, Judge.
Thank you. Am I going to see Mr. Pierce again?
Hopefully not.
Good. Okay. Thanks, Mr. Pierce.
So what would you like the minutes to?
That, quote, supervised contact, close quote, includes overnight with the minor, J period, P period, only, and an adult, in parentheses, 18 years or older, other than the defendant. Thank you. Thank you, Mr. Schweitzer. Mr. Klein, you ready?
I'm ready with one of the cases, Your Honor.
Mr. Moore,
I did talk to Mr. Moore, and he said you would be here no later than 10:30, so he just hadn't talked to me to ride. So I did talk to him.
Judge, I do have one in the gallery. That's Jason Willis.
Yes, sir. Thank you.
Mr. Willis is approaching in 23 CDAP 502. This is an add-on for an early plea.
Yes, sir.
Mr. Willis would be entering a plea as charged. He would be sentenced to credit for time served, an adjudication of guilt. He has previously been adjudicated. $515 report costs and $150 cost of defense. Mr. Willis is going to ask the court for 6 months to pay off those financials before they're sent to collections or civil lien. May I approach?
Yes, sir. So Willis, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Willis, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Yes, ma'am, to the state?
Judge, just to be clear, this is an agreed upon downward departure.
Good. Mr. Willis, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs, $150. public defender's fee if you fail to pay those within 6 months from today. Then they will go to a civil lien or judgment. Thank you, sir. Good luck to you. And you'll give me a score sheet? Folks waiting in the gallery, they're waiting for inmates.
Your Honor, there's Ms. Rogers.
Ms. Rogers, please, come down.
Your Honor, I'm not entirely sure. I think she may have been on the arraignment docket, but Madam Clerk can tell Ms. Rogers. Roberts.
Okay.
Patricia Roberts?
Yes.
Oh, she is on the 139, that's fine.
I guess I'm in the wrong place, I was still in the other courtroom.
You're just early, and that's correct. 23 CF 1576. Is an information file? Ms. Roberts, go ahead.
Is this Roberts?
Roberts, yes, ma'am. It's number 27 on the 135.
Judge, at this point, I'm doing a little bit of work on the case. I think I can represent to the court at this point that more than likely we won't be going forward with this case. But I've done some background work on it, and so at this point, I would ask to pass the case to the next plea day.
Okay. The next arraignment will be August 24th. So, Ms. Roberts, since I don't have the information yet, I'll see you back here on on August 24th at 1:30. If the state dismisses the case, then you'll send that to Ms. Roberts?
Yes, Judge.
Good. Thank you, ma'am.
Thank you very much.
Mr. McKinney's inmate starting with others results. Judge, I have a score sheet for Mr. Willis.
Please.
Good morning, how are you?
I'm doing well. How are you?
I've been better than other ones.
Yes, ma'am. We'll see if they can work something out.
Yes, sir. Yes, sir.
Judge, we have agreed upon terms, we're just trying to clear up the scrivener's error.
Okay.
2014. did.
Judge, before we move into plea agreements, Ms. Randolph is returned to us from Florida State Hospital. I reviewed those reports. I've met with her at the jail. I have no concerns related to her competence. We stipulate this court reviewing those reports from Florida State Hospital and making a decision of competence.
Is this going to the pretrial intervention program?
It is.
Is this the referral? This was what? Is that what she needs to sign?
I have all those documents here for her to sign because there is a change to those documents, but before we move into those documents, we would make sure that she's, that the court has deemed her competent to proceed.
Good, hold on one second. And thanks for making sure that the court rules on that. The court does find Ms. Randolph competent to proceed.
Thank you, Judge. And Ms. Randolph is here in 21 CF 2108. And the agreed upon resolution in this case is going to be referral to the PTI program. And there is going to be a plea agreement behind the PTI here. So if there's any non-compliance or violation to the PTI, that she would be returned to the court for sentencing. Ms. Randolph has signed a plea agreement that we would be handing to the court today that would be held by the court and only entered if there's non-compliance or violation of the PTI.
Okay. When you say held by the court?
It's not entered, but it would go into the court record today, acknowledging that plea
So it's
agreement.
just filed with the clerk?
Correct.
But there's no sentence?
Correct.
Good.
And Ms. Randolph has signed for referral to the pretrial intervention program paperwork. There's some modifications to that document that everybody's initialed on, which removes some of the costs. And there are the same revisions on the actual pretrial intervention agreement that have been initialed by the parties. And Ms. Randolph did sign those documents after those revisions were made. And we are very lucky today in that Ms. Barres is actually in the courtroom with us today. So I'm going to hand this paperwork for her signature back to probation. And Madam Clerk, since this is not how we normally do this, if I hand the document signed by everybody to you, is that something that can be filed here in court? Okay. So Judge, I'm going to hand these documents to you, but really it looks like PTI is for Madam Clerk. Just making sure that everything is signed. May I approach?
Please. Thank you, sir.
Yes.
For the record, the state will submit a score sheet, but she does score 41.6 points with a maximum of 11 years.
Ms. Randolph, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand out. So, Ms. Randolph, the biggest concern for the court at this juncture is to make sure that you understand your possible downsides.
Okay.
And so, you signed the plea agreement,
Yes, sir.
correct? In there, it shows that you could be sentenced to up to 11 years in prison. Do you understand that?
Yes, sir.
Do you understand the only possibility of you being subjected to any sentencing would be if you don't successfully complete the pretrial intervention program?
Yes, sir.
Do you have any questions for the court or your attorney or the state regarding that?
I don't think so. I think we've gone over it pretty thoroughly.
Okay. And so you are, if I accept your plea, you're waiving your right to a trial by jury to determine guilt or not. Do you
Yes, sir.
understand that?
Yes, sir.
Okay. I'm going to ask you a few more questions since the possible downside is prison. Let me go through a longer colloquy with you, a series of questions. Are you currently under the influence of any drugs, alcohol, or medication?
I did have my medication this morning.
Okay. So what were the crimes that you were charged with?
Child abuse without bodily harm, leaving the scene of a crash, resisting an officer without violence.
Okay. How far did you go in school?
I have a bachelor's degree.
Okay. Did you read the plea agreement?
I did.
Do you understand it?
I believe so, yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
Very much so. Thank you.
Did you sign the plea agreement?
I did.
Ms. Randolph, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for the entering of the plea. Anything else from the state?
No, Your Honor.
Ms. Randolph, I wish you the best, ma'am.
Thank you, sir.
Yes, ma'am.
That's where the office is located at 13 Kelly Avenue, just in case you need it. These are addresses on High Street, 341.
Okay.
And that's the defendant's home, which is perfect.
Okay.
All the way to that side.
Okay.
Do you have every vehicle
Can I return that email? And I think it was bars and it's fine to give a call.
my last draw on the way out?
Okay, and you want a copy of that? Thank you.
So this way, for us,
Next is going to be Marquise Watson.
Thank you.
Marquise Watson.
Judge, this is Marquise Watson before the court for 23 CF 1647.
Yes, sir.
We're on the docket today for a bond reduction hearing.
Yes, sir. Mr. Watson, the motion says that you've been in jail since July 22nd of this year. The current bail is $7,500. You're employed at Baytown Wharf and also LL Moving. You've lived in the area for 1 year and that you have 2 children.
Yes, sir.
Mr. McKinney?
Judge, may I have 1 moment?
Sir?
I do want to ask a few questions of Mr. Watson.
Mr. Watson, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand.
Mr. Watson, at the time that this is alleged to have occurred, were you actually residing at the 921 Denton Boulevard apartment in Fort Walton Beach?
Yes, sir.
So if you were released upon bond, can you make arrangements to live somewhere other than that apartment where this is alleged to have occurred?
Yes, sir.
And can you describe for the court what your plan will be upon release if you were released upon bond?
I'll be staying at 915 Harrison Drive, 32547. Yes, sir.
And are you going to have any issue in complying with the court order if you, for you to have no contact with Ms. Squire, who is known as the victim here?
I have no issue.
That's even though there is a child in common?
Yes, sir.
Do you have any objection to any GPS monitoring or any pretrial services that the court may seek to impose?
I have no problem.
Do you believe you can go back to work at Baytown Wharf or the L&L moving if you were released at this point?
Yes, sir. I can go back to both jobs.
Okay. What were you doing at Baytown Wharf?
Maintenance. Yes, sir.
I have no further questions for Mr. Watson.
Does the state have any questions for Mr. Watson?
No, Your Honor.
Thank you.
That's all I have. Judge, Mr. Watson's been unable to make his bond in the cash professional. We recognize that this is an aggravated stalking case, but given that Mr. Watson has very limited, if any, criminal history, we are seeking a signature bond, and if the court is concerned about Mr. Watson going around or being near the apartment, obviously he's made arrangements of somewhere else to stay. The court can impose GPS, pretrial services. The first appearance court did impose pretrial services with GPS monitoring set at $1 per day. We would ask the court to keep those conditions as it fashions a bond, but we were asking the court to consider reducing the cash professional aspect of his bond to a signature so that he would be able to bond out.
Thank you. To the state?
Judge, at this point, Mr. Watson's bond is set at $7,500 cash and professional. The state at this point feels that that is an appropriate bond. We have not been able to speak to the victim in this case. My concern in reading through the report, it reflects that the victim is very scared of the defendant. So I have nothing to go on other than what the report says at this point. Now, I can explain to the court, Mr. Watson does not have an extensive prior history. Mr. Watson has a very limited history of some criminal traffic charges, but what I do see is it looks like he has an FTA from 2019 in Baldwin County, and then of those criminal traffic charges here in Okaloosa County, there was also a failure to appear. So although his record is limited, my concern is that he has not appeared before the court when required to do so.
And all of those things happened within the last year?
2019 was Baldwin County, and 2021 was the FTA for the criminal traffic case. It was a 2020 case that had a 2021 FTA, and then there was also a 2021 criminal traffic case as well, that I didn't see that there was an FTA on at this point. So, based on, I'm sure Your Honor always does his homework, and I'm sure has read through the arrest report.
Yes,
so I don't want to stand here to go back over that. But at this point, based on what we have, knowledge of the allegations and Mr. Watson's history, the state would feel that the $7,500 cash professional bond is sufficient in this case.
Thank you. Mr. McKinney?
The two things I would point out would be the failures to appear for criminal traffic cases that the state are referencing turned out to be, they were financial only. He did end up paying those tickets. And when you look at the arrest report, it makes it seem like this is not a shared apartment. Mr. Watson was living at that address at the time with the mother of his child when this was alleged to have occurred.
I understand. And I did, Mr. Watson, I did read through the arrest report,
Yes, sir.
the couple quotes that are in there.
Yes, sir.
Blow the brains out,
Yes, sir.
sit there until this person comes out. I don't make any determination on facts because I don't have those before me. When I did my homework and read the motion for bond reduction, one of the things, in addition to what I read, I highlighted all those things, but I underlined 1 year because I do have concerns about I want somebody else out there looking for you if you're not present. 1 year in the area gives me some concern, especially in light of what the state just brought to my attention as far as the failure to appear. There was certainly, every judge has the concern of if you had a lot of money, you would be out right now. And so what does the court do at this juncture with a relatively low bond of $7,500? Does the court just say, if he had more money, he would have posted it, so let's make it a signature? I don't think that's what the law is. That decision's easier on the court today because of you being in the area only 1 year and because of what the state raised. So respectfully, your motion for bond reduction is denied. So it will remain the same. When will I see Mr. Watson next?
Judge, Mr. Watson is set for felony arraignment next week on the 24th. Madam Clerk, has any information been filed in this case? So, Your Honor, we'll see him on the 24th next week.
I'll see you next week.
All right.
Thank you, sir.
Next is Jeremy Whitfield.
So, Mr. Whitfield. Good, how are you? Good. Mr. Whitfield, the motion for bond reduction, things that I highlighted were that you've been in jail since July 30th of this year. Present bail is $3,500. That you're unemployed, you've lived in the area 40 years, and I underline that. That you're single, and that your sister lives in Crescent.
Yes, sir. That's my whole life. Judge, there's been some negotiation with the state related to this case, and I believe that the state has filed an information and discovery, which will be something that we need prior to entering any type of plea agreements. That's a long way of saying, can we bring this back on Monday at 9 a.m.? We have a relatively short docket, and we may be able to resolve the case if we continue this bond hearing until Monday morning.
We've got a really short docket on Monday.
Right. So there may be a beneficial offer for Mr. Whitfield if we pass until Monday.
Mr. Whitfield, do you agree to continue your hearing until Monday?
Why haven't we finished that?
Sir? You agree to continuing this hearing until Monday?
Absolutely.
Okay, I'll see you then.
Thank you, sir.
Thank you, sir.
Next is Rico Williams.
Judge, as Mr. Williams approaches in 23 CF 1332, he is set for a bond hearing. However, I believe that the state is going to stipulate to a signature bond in this case. I'll let the state speak for themselves.
To the state.
Judge, at this point, reading through the records, although Mr. Williams has an extensive record, it looks like what the suggestion was from pretrial for first appearance was that Mr. Williams receive a signature bond. So at this point, we would stipulate to converting the cash professional bonds to signature bonds.
Okay. Mr. Williams, your motion is granted, and so the bond amounts are signature bonds. Is it more than one count?
It is.
3 counts, Judge.
Three counts, and then there's a fourth count with an ROR.
Okay. So the cash or professional bonds are signature bonds, so you'll be able to sign out.
Thank you.
Do I see Mr. Williams on the 11th?
Judge, he is set for the 11th for pretrial.
Okay. I'll see you back here at 9 o'clock on September 11th.
Thank
you, sir.
Oh, are you good? Yeah. Okay. Yes, sir. I will.
Next is Isaac Woodard.
Judge, in all candor to the court, I've been working with Ms. Davis and trying to resolve Mr. Woodard and Mr. Youngblood's case. That's the next two cases for bond reduction hearing.
Yes, sir.
And I don't believe that's going to line up for today, but it could line up with favorable resolutions for both if we could set them on Monday as well.
Okay. Yes, sir.
This is Mr. Isaac Woodard before the court at 23 CF 1740 and 23 CF 1741. He is set for a bond hearing here today. However, we are trying to resolve this matter, and I believe that we're close in doing that. So I would ask to continue this hearing until Monday morning at 9 a.m.
Mr. Woodard, do you agree to continue this hearing
Yes,
until
sir.
Monday?
Yes, sir.
Okay, then I'll see you Monday morning.
Monday morning.
Thank you, sir.
And next is Anthony Youngblood.
Judge, this is Mr. Anthony Youngblood before the court, 23 CF 1736. Judge, this is Mr. Youngblood before the court in 23 CF 1736. In discussing what I've learned here in the courtroom, he wants to go ahead and have the bond hearing here today.
Okay.
And
So, Mr. Youngblood, when I read your motion, here's what I highlighted. Is that you've been in jail since August 2nd of this year. Present bail is $8,000. You're employed at a recycling center. You've lived in the local area your entire life, and I underline that. You have one child, cousin, and extended family that live in the local area, and you obtained your GED, which I make a note of that because I know that's self-motivated. You're the reason why you pushed through and got that, and congratulations on it. Mr. McKinney.
Judge, what was said at first appearance was $2,000 cash professional on 4 counts. There was a possession of paraphernalia with a $1,000 signature bond. We're asking the court to consider changing the cash professional bonds to signature bonds. There's no listed victim in this case. It's possession of controlled substance only. And if you look to the weight of the evidence within what you read in the probable cause, you'll see that the officer stated that there were 2 people sitting on a bench when Mr. Youngblood got up to leave. That's when the officer located some substances. We're asking the court to consider that set of facts in asking for a signature bond for Mr. Youngblood in 23 CF 1736.
Thank you. To the state.
Judge, Your Honor has seen the first, or the arrest report, I'm sure.
Yes,
so I'm not going to go through all that. Now, it's not just simple possessions. The way it's been charged at this point, it's a sale, manufacture, deliver charges. So I want to make sure that we're clear on that. Mr. Youngblood has quite an extensive history before the court regarding substances as well as DWLSR, burglary, grand theft. So I see at least 2 very recent cases of possession of controlled substance and more possession of controlled substance going back. There's 2013. 2006, so 2002. So again, we have a pretty extensive history here of possession of a controlled substance that it definitely gives concern to the state. It looks like the last time that he entered a plea on possession of a controlled substance was in 2021. So based on the fact that we're talking about sale manufacture charges and with Mr. Youngblood's extensive history, the state would oppose lowering the bond to anything less than the current $2,000 cash professional.
Explain, and I did read through the arrest report, highlighted different things in there. How do these facts arise to sale manufacture when it says 8 clear bagging, and then it says tested positive for methamphetamine, and then it says cigar wrap package, singular, tested positive for fentanyl, and then a single still, and then it says a sealed package of Suboxone. So those individual packs.
The arrest
having all of
report,
those
right, the arrest report reflects possession of a controlled substance, but that's not what was docketed by the clerk's office. So I'm not sure what happened from there.
Judge, I don't believe an information's been filed in this case yet. I only see possession when I read the arrest report and you can see it, look at the first appearance paperwork.
Okay. So that hadn't been charged?
No, Judge, this was an August 2nd arrest.
Correct.
Mr. Youngblood, that was going to make a big difference to the court as far as whether to grant your motion or not. I do have concerns about what the state stated as far as the things that are outside the four corners of the arrest report. But your motion for bond reduction is granted, so you will be able to sign for those two cash or professional bonds. Do you still want the hearing on Monday?
Judge, since he's going to be getting out, I would prefer for him to come meet with me at my office. If we have an agreement that we've reached with the state, we can always add this back on.
So I'll see Mr. Youngblood on September 11th. Is that accurate?
He is scheduled for felony arraignment on the 14th of September. So that would be his next court appearance.
Okay, so September 14th at 1:30. I'll see you then.
Yes,
Stay in
sir.
touch with Mr. McKinney.
Yes, sir.
Thank you, sir.
Yes, sir, can. So
When you get out, come meet with me, okay?
Thank you, sir.
Yes, sir.
Judge, I do, well, just before Mr. Youngblood leaves the courtroom, I had made, Mr. McKinney and I had discussed the potential of an early plea offer of credit for time served. With the case moving forward past a very quick resolution, at this point, the offers are really going to turn into a probation offer with the extensive history of Mr. Youngblood, so I want to make sure that we're clear on that.
So Mr. Youngblood, here's your homework. Your homework, stay in touch with Mr. McKinney, but the court can't make the state hold an offer open to you. So the state can withdraw it this afternoon if they want to, and I can't make them reinstate it. So just the longer you wait to address the state's offer, just know the more risk there is. But you need to talk to Mr. McKinney about what you want to do. If you want to enter a plea sooner, next week, Mr. McKinney can set a hearing then.
Yeah, just make an appointment to come see me as soon as you get out.
Yes, sir.
Anyone else in the back?
Yes, I have two with Mr. Hines.
Thanks.
Just McBride, Julie McBride.
And Your Honor, I just got a text from Mr. Notes. He's on his way. He was in traffic court. Just want me to look forward.
Good, thank you.
Not just leaving it.
Your Honor, this is Ms. McBride. Just for the court's benefit, Ms. McBride is, the state and Ms. McBride are kind of going back and forth on getting Ms. McBride into a certain program. That's a program at Bridgeway. I did this morning, I emailed Ms. Cindy Myers to have Ms. McBride evaluated. I talked to Bridgeway. We're looking at about a week timeline. So I don't want to kick Ms. McBride down to September 14th. I would ask the court to put it on the August 24th docket, a week from today, to see if we can potentially get this resolved.
Okay. Ms. McBride, I'll see you a week from today, okay?
I'll come see you.
Next we have El Shaddai Neal.
Sign date. Today's the 7th. Your Honor, this is L. Shabazz Neal. He's got a VOP in 22 CF 3042. He's got a new law violation in 23 CF 1337. He has reached an agreement with the state to resolve these two cases. In 23 CF 1337, that is a new law violation. Mr. Neal is going to be entering a no contest plea as charged. In that particular case, Mr. Neal will be placed on 2 years of drug offender probation with a curfew from 10 to 6. You got it? All right. He will submit to a substance abuse evaluation within 30 days, begin any recommended outpatient treatment within 60 days, be assessed $615 in court costs, $150 in public defender fees. He would be adjudicated on this case. He was previously adjudicated in 22 CF 3042. That is the violation of probation. In that particular case, his previous supervision will be revoked and terminated. He will start a new period of 2 years of drug offender probation with a 10 to 6 curfew, the substance abuse evaluation within 30 days, must begin any treatment within 60 days. In that case, it would be a $100 cost of prosecution, a $100 public defender fee, and I believe that's it.
Okay.
May I approach?
Sure.
And I have 2 different plea forms because of the number of charges.
Thank you. Mr. Neal? Yes, sir. Do you have questions for Mr. Clons?
No, sir.
Okay, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, sir, you can put your hand down. Mr. Neal, did you read the plea agreements?
Yes, sir.
Do you understand them?
Yes, sir.
Did you discuss them with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Very.
Did you sign the plea agreement?
Yes, sir.
Mr. Neal, I do accept your plea. You're adjudicated guilty in both cases. Yes, sir. Thank you. Thank you, sir. You're adjudicated guilty in both cases. You're sentenced, and your prior supervision is revoked and terminated. You're sentenced to 2 years drug offender probation, and it's not drug offender probation in the BOP case, correct?
It is, Your Honor. It's drug offender probation concurrent between the cases.
2 years drug offender probation in each case to run concurrently, run at the same time. You have a 10 p.m. to 6 a.m. curfew. You'll need to submit to a substance abuse evaluation within 30 days from today and begin any treatment if it's recommended within 60 days from today. There's a total of $250 public defender's fee. You need to pay the court costs in the new case and the $100 VOP fee in the VOP case. Good luck to you, Mr. Neal.
Thank you.
Thank you, sir.
Yes, sir.
Yeah.
And yes, he is on the 130 docket, so we could take him off of that docket.
So, Mr. Klein's on the 130 docket. You are accepting the information and waiving?
Yes, Your Honor. I forgot that he was on the 130 docket, so we'll waive the formal reading and enter a plea consistent with the plea agreement.
Thank you, sir.
Thank you.
Rachel, who's next?
There's no more inmates such besides the one for Marty Notes.
Okay. And what happened with, so we did notes, what happened, we did Mr. Cotton. What about Patel probation? We did that. Okay. So just Mr. Notes, and we'll take a break, and then we also have the sentencing.
The case for Randy Patton was taken care of by the court. Was probably why Mr. Patel's not here.
Okay, good, thank you.
Judge, we have Tamasha High on the docket, 19 CF 1225.
Yes, sir.
My office has told me that she is trying to get here, so I'm going to ask the court to call her later to see if it's a VOP arraignment.
Okay, let's take a 10-minute recess and then we'll come back and finish up.
All rise, please.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Imagine I should go look for Mr. Clark.
He's right outside the door.
But is he by himself?
He's by himself.
Is he talking to him? Mr. Carnes, what have you heard from Mr. Moore?
I just talked to Mr. Moore. He advised me he was passing the IHOP and the Lowe's and should be here any minute.
Okay.
So,
Okay, and then who else is on the docket? Then we have Mr. Cott. No, we did Mr. Cott, right?
We have Miss
Mr. Wright,
Mr. McKinney.
Judge, I have heard from Ms. High, but she is not here yet. Oh, I know. Could I address the matter on the 130?
Sir, please do.
Filibuster
as much as you can.
Right. There's an individual on the 130 docket. His name is Ricky Minor. Madam Clerk, that'd be 23 CF 1581. Late yesterday, I filed a written not guilty plea for Mr. Minor. He is in the Federal Bureau of Prisons. I talked to his federal public defender, and he's serving, I believe, about 18 months. I was going to ask the court today for a one-cycle continuance for Mr. Minor so I can track him down. My understanding, talking with his federal public defender, is that he wants to enter a plea in this case. I have no idea how receptive the Bureau of Prisons would be to a Zoom appearance, but I definitely don't want him to get a capias on 9/11 knowing that he's in custody. So I would ask the court to continue this to the November 13th docket. If we can get this resolved by an early plea, I'll advance it on the earliest docket I can, though.
Any objection from the state?
No objection, Your Honor.
It's continued until November 13th.
Thank you, Your Honor.
Bridget, we want to take a recess until Mr. Moore appears, and then you let me know, and I'll come back from the bench. Okay. With the understanding that Mr. Moore is just down the street.
Yes, sir. I was going to go post up in the hallway and catch me.
We're in recess until Mr. Moore is here, or 11 o'clock, whichever is soon. Thank you.
All rise, please.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with McBride Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Discussing things with Mr. Moore this morning. I do believe Mr. Moore is going to request that the court give him until Monday to have this sentence imposed, but I think the court should inquire of Mr. Moore. He knows much more about the reason why the request is being made than I do.
Okay, Mr. Moore, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Do you put your hand up? What would you like for me to know?
Well, first I would apologize for being late today. That's the main reason, is I didn't know my girl was going to have car troubles. There's literally a bottom engine knock on the car we just bought, you know. We just can't catch a break, and I had to go to bed because my daughter just started cheerleading. Just trying to get that situated.
I believe the request is that there was unexpected car trouble this morning. Sounds like they just purchased a car and is trying to get that addressed, I assume.
To the state?
The state will have no objection to setting it until Monday to impose the sentence.
Mr. Moore, I certainly didn't think the state was going to not object. I certainly don't have any.
He said that.
Yes, sir. I don't have any objection to that.
Yeah, I'm always showing up on time. I'm always, you know what I mean?
Just make sure that you're on time. To be honest with you, I had a Post-it that I put on my docket when I was doing my homework earlier.
Yes, sir.
And what it said was, if you were here at 9 o'clock in the morning, I was going to say, Mr. Moore, do you have family that's here with you? You know, do you want to be sentenced now, immediately at 9? Did you want to wait until right before the break? I was trying to, you know, help the anxiety.
Yeah, I appreciate
that.
Not knowing the situation too, you just simply thought about that. I appreciate that.
Yes, sir. So I'll see you at 9 o'clock Monday morning.
I'll be
Make
here
sure
at
you-
9, for
Yes,
sure.
Just so we're all aware, the docket on Monday is exceedingly light, okay?
Yeah.
So,
Yeah, he's not gonna have any hesitance on, hey, he's gotta get these.
Right, if I have to leave the bench and you're not here,
Yes,
because the
sir.
docket runs out, then there'll be a KPS out.
Awesome, thank you.
I'll see you at 8:50 Monday morning.
Yes, sir.
All right.
Thanks, Sean.
I have, Ms. High is here.
Ms. High, come on up. Judge, the state wouldn't have any objection to Ms. High staying in the gallery.
Oh, okay.
Judge, she is present in 19 CF 1225.
Ms. High, you're fine. You can stay there.
She has some mobility issues because of Parkinson's. You're fine.
Ms. High, you're fine. You can stay there as long as you can hear us. Okay? Thank you.
My daughter's here, but she changed the baby. I'm sorry, Judge.
No, you don't need to apologize for your physical condition, Ms. I.
I'll be honest, I know I ain't had stuff, probation.
Judge, she's here for a violation of probation. There are outstanding conditions. We're going to enter a denial today and ask for a court date set in October. I'd like to sit down and meet with Ms. High to see what we can reasonably accomplish on the conditions that are left and speak with the state about an agreed upon resolution.
Okay. So Ms. High, I'll see you back here on October 12th at 9 o'clock, okay? So October 12th, 9 o'clock, stay in touch with Mr. McKinney.
Your Honor, I will say, it's a lot of stuff, the conditions y'all got me under.
Miss I?
Yeah.
Who is to your right? Who are the two individuals
Oh,
to your
this
right?
is my daughter. She just came here 2 weeks ago, and this is my first grandchild.
Congratulations.
Yeah. Wow. You met her brother. You already know I know.
Thanks, y'all. Thank you. Okay, anything else on the docket for this morning?
There are no miles, Mr. Notes.
Have we heard anything from Mr. Notes?
All I got was the text message at 10:20 that said that he just got out of court in Santa Rosa and was headed to Okaloosa now.
Okay. Then I think that we'll see Mr. Notes at 1:30 or 2:30.
I'll text him that.
Okay. So we're in recess until 1:30?
All rise, please.